So thank you all for being here. It's a pleasure to be in the show, as it were, the big room. I have a few reminders before we get started. Please turn off your cell phones. If you want CLE credit, you need to get your card scanned, either as you're coming in or as you're going out, or both. And then we will have some conversation up here, and then we will have a Q&A. In order to do that, there are cards on your table, and you should write down your questions in your best handwriting, and then wave them around about an hour in, and someone will come and collect them. And then they will give them to me, and I will decide whether to ask them by how good your handwriting is. That's how it's going to work. But thank you so much. So my name is Rich Schrager. I'm a professor at the University of Virginia School of Law. It's a pleasure for me to be here today to moderate a panel near and dear to my heart. I write about cities, so one day maybe we'll have a panel about city power, but we're starting to get down there. So today's panel, of course, is about state courts. The title is Into the Breach: Relying on State Courts and Constitutions to Safeguard Rights. And we have just an all-star panel here. A pleasure. Thank you for all coming. I'll start at the end and just introduce the panelists quite quickly. The Honorable Goodwin Liu is on our end. He's an Associate Justice for the California Supreme Court and previously a Professor of Law at the University of California, Berkeley School of Law. To his left is the Honorable Anita Earls. She's an Associate Justice for the North Carolina Supreme Court. She's been in that position for 6 months, so a new justice. Before that, she was the founder and executive director of the Southern Coalition for Social Justice. Right to my right is the Honorable Jeff Sutton, and he is a judge on the U.S. Court of Appeals for the Sixth Circuit, the one federal representative. Don't boo him at this point, it's okay. But he was the state solicitor of Ohio, and he's written a great book called 51 Imperfect Solutions, States and the Making of American Constitutional Law, which I hope we'll get a chance to talk about. To my left is Mary Bonato. She is the Civil Rights Project Director for GLBTQ Legal Advocates and Defenders, or GLAAD. She was the lead counsel in Goodridge and argued in Obergefell, among other cases. To her left is, I'm going through my list, Alice O'Brien. She's the General Counsel of the National Education Association. Previous to that, she was the chief counsel to the California Teachers Association. And then last but not least on the end is Caitlin Halligan. Caitlin is a partner in Salendi and Gay, LLC, but has held other positions, again, in state government. She was Solicitor General for the state of New York and General Counsel to the New York County District Attorney's Office prior to that, among other positions. So I wanted to start with the judges and justices, since we have them here and we can talk to them about state courts. And the prompt for this panel starts with Justice William Brennan's observation in 1977, so quite a bit of time ago, that state courts should be a realm for pursuing individual rights claims. He was skeptical, in fact, of the U.S. Supreme Court as fulfilling those duties or obligations towards the ends that he was interested in. And he was urging people in this Harvard Law Review article to look to their state courts. And some of that has happened over time. But I'm not sure we've gotten there in terms of Brennan's vision. We can talk a little bit about that. What is your perspective, and maybe we'll start in the end, Justice Liu, what is your perspective from the state courts in terms of seeing rights claims being made there and the effectiveness of doing so?
Great, well thank you, Rich, and it's wonderful to be here at the ACS convention. In the immortal words of Lin-Manuel Miranda, it's great to be in the room where it happens. That's right. And it's wonderful to be on this panel with Caleb, Alice, Mary, Rich, and Anita, and my good friend Jeff Sutton, who I will put in a plug now, has written a terrific book, which I commend to you. And I owe Jeff actually a great deal of my own study and knowledge about this subject, even before assuming my position, and especially during my tenure. We've had many productive and enjoyable discussions about state constitutionalism, so this should be a very fun experience for all of us. So a bit of history, I think, is useful, and a bit of context. The context, I think, is that most of this conference and most of what you learn in law school is centered on federal constitutional law, and you study the handiwork of people like Judge Sutton and his upstairs colleagues at the US Supreme Court, and comparatively little attention is paid to state constitutions, and this reflects, I think, a lot of different kinds of biases in our legal education and of the professors of which I used to be one, in the way we were educated. But it turns out that on day one of practice, for most of you who go into practice, you are going to confront a whole bunch of different realities. The reality is that if you think about where filings happen across this country, in a given year, there are roughly 400,000 new filings in federal court. Anybody have a guess as to how many new filings happen in state courts throughout America? 50 million, 50 million, right? So two magnitudes higher than in the federal courts. If you think about how many judges there are roughly 800 some odd Article III judges in America. Any guess as to how many state judges there are in America? 13,000, okay? So inevitably, you're going to come upon a legal system, right, which is heavily dominated actually by state law, state judges, state forums. And sadly, virtually none of your law school education will have prepared you for this. But you're at this panel, so that'll be a good start. Justice Brennan was writing in 1977, right at the end, he was already at the end of the Warren Court, and change was in the wind because at that point, President Nixon had appointed 4 justices to the Supreme Court. If you just pause and think about that for a second, it's amazing that Richard Nixon appointed 4 justices to the US Supreme Court. But he understood that change was afoot in terms of many of the precedents and lines of law that had been being developed in a certain direction under the Warren Court. And so he started to think about, in this very slim article, by the way, that article was only 16 pages long, take note, you law review editors. That article is one of the 10 most cited articles of all time, so brevity. In which he basically argued that the US Supreme Court was headed in the wrong direction on individual rights. And he basically said state courts who always must adhere to the federal floor in terms of protecting individual rights, they are bound by the federal floor under the Supremacy Clause, nonetheless can protect individual rights to a higher threshold if they so choose under their state constitutions. Brennan, I think, quite overtly advanced this thesis as a way to essentially backfill what he regarded as wrong decisions of the US Supreme Court. And in that slim 16-page article, he cited no fewer than 36 of his own dissents, right, in these cases that he thought wrongly decided, which he then urged state judges to adopt as the majority positions under state constitutions. This, I think, was an interesting project and caught a lot of people's attention, but never kind of fully got legs because of its, sort of one-way ratchet orientation, and it seemed a little too results-oriented. I think what I've discovered, both through conversations with Jeff and others, and in researching this issue myself, is that we should come to understand state constitutionalism and the role of state courts not in terms of liberal or conservative, because by the way, there are a lot of individual rights that you might think sound a little more conservative: gun rights, economic due process rights, takings, rights against takings, these kinds of things, right? And those too are individual rights. Anti-discrimination rights brought in an affirmative action context, okay? These are all rights too, and you might think they have a slightly more conservative bent. My point is that that is immaterial. The proper understanding, I think, of this issue begins with structure. Why should we have a system of two courts in America? It is the same reason that we have a system of two sovereigns in America. And that is because the framers of our Constitution, in their wisdom, decided that it was important to have multiple locations and multiple forums for the inevitable debate and diversity that would occur in a large nation with respect to even the most fundamental understandings of what our Constitution guarantees. And so we do have we have these multiple outlets for debate. We have multiple outlets for elaboration of the meaning of rights. And if you think about the morning panel, and just to recap, it was about reforming the US Supreme Court, and there were all these proposals for how to get that one court to be more fair. Well, that's the whole premise of that panel, was the all-important nature of that single court. But as I sat there listening to it, of course, I thought, well, if you brought in a whole bunch of other courts and other forums into the picture, that's one other way that we provide outlet. Now, of course, I'll just conclude with this. Everybody has their set of favorite rights, right, that they want enshrined at the highest level of decision-making in the Constitution. Perhaps we ought to think, and the idea of federalism need not be antithetical to the idea that there are certain all-important things that everyone in the country has to adhere to. But we might think about structure as a way of pacing and modulating and adding nuance to the process by which that occurs. And if you read Jeff's book and you look at, we have Mary here who can tell us a lot about this issue, I believe. Rights don't just come into being at the snap of a finger. There is a process. It's a historical process. And if you're a careful student of history, you will see errors and you'll see successes in terms of how that happens. And I think, again, we ought to think about state constitutionalism through this lens of process and structure, and not in terms of liberal or conservative results.
Justice Earls, what do you see from North Carolina? So it's a slightly different political setting than Justice Liu is dealing with, and that might make a big difference. I don't know, in terms of how you see the possibilities of state courts.
Well, I think first also let me say thank you so much. I'm honored to be on this panel, and I really want to thank ACS because the opportunity to come together in this forum and learn from some of the brightest and most amazing people in the country has been one I've been able to take advantage of from time to time. And it really has been influential in my career in many ways. So I'm grateful to ACS and grateful to all of you for being here. I have only been a judge for 6 months, but I actually was a lawyer for 30 years before that, litigating civil rights cases. And so then as I had to campaign for this seat, because judges in North Carolina are elected, I spent a year going around the state explaining to voters what our courts do, why they should care about the Supreme Court, and why I, as someone who had been a litigator filing lawsuits in state and federal court, why I thought our state court was important. And I think it often resonated with people because they actually feel closer to their state courts. Even if they don't end up having a case before the state Supreme Court, a lot of what we decide impacts their lives very directly. And if you think about criminal justice system reform, I would say 70% of the cases that my court deals with are criminal cases. And how we interpret our criminal statutes, how we interpret our criminal law is impacting mass incarceration and what's happening in our communities. So that I think people could understand why state courts matter. I decided to run for the court because I felt like in the near future, the clients and the communities who I'd advocated for 30 years needed that forum to be one that was open to them, that they needed to have that alternative route. And we do have some examples of state court opinions that expand rights beyond what the federal doctrine has, even in North Carolina. we have said that our equal protection clause means that judicial districts have to be the same size, whereas under federal law, the courts have said that one person, one vote doesn't apply to judicial districts. We are a court that said that the good faith exception to the exclusionary rule would not apply under the state constitution. Now, we had a legislature that came in and actually passed a law subsequent to that saying they didn't agree. So we do have, we have our fights with the legislature. But my point is that in the past, our court and other state courts around the country have, and I think in some sense being close to the people and sometimes being elected, sometimes feeling answerable to the communities that they live in a slightly different way, it means that they have found greater protection of rights and that it's a really important avenue that shouldn't be neglected.
So let me bring in the litigators to talk a little bit about areas that seem ripe, and you've all had experience doing this in state courts. Maybe we start with Mary. Why state courts? What was the rationale for that? Is there a difference in litigating in state courts and thinking about that as an avenue? And then we'll get Allison here and Caitlin in here too.
Sure, my experience really relates primarily to challenges to sodomy laws in the states into litigating for marriage. But I think I'd be remiss if I didn't say that I think people, the last time someone counted how many state cases there were where the Constitution provided greater protections than the federal, they were over 1,000, and people stopped counting. And the justice brings up criminal procedure issues. That's an example of many. Death penalty decisions, all kinds of things. So I'm extremely excited about this whole area of law. I feel like we have a lot of places and provisions where we really can kick the tires. But having said that, preliminarily, and the sodomy issue, in 1986, the Supreme Court decided Bowers versus Hardwick, and literally said that the claim of liberty in that case was at best facetious, which definitely made a lot of people really mad, and drove a lot of people to court in states, under state constitutions. And when I look back sometimes, at the time it all seemed like exactly right and just, and we had great arguments, but we won under state constitutions, and these were privacy claims, either explicit or implicit protections for privacy, and equal protection, because it was same-sex couples who were being penalized for behavior that everyone else engaged in too. But we won in the 80s and the 90s in places like Kentucky, Tennessee, and Arkansas. And at the time we lost Bowers versus Hardwick, there were 25 states with sodomy bans. And by the time we got to Lawrence versus Texas in 2003, there were only 13 left because there were repeals and there were these state cases. And one of the points that the majority made in Lawrence was how the decision in Bowers had come under unrelenting criticism, and the actions that had happened in the states that were, I think, part of how after 17 years they were able to dismantle that precedent and not apologize, but to say that Hardwick was wrong and decided and wrong today, and that the court had misapprehended the claim of liberty at stake. So that's a situation where there was no choice. Just briefly about marriage? Mm-hmm. Yeah. Okay. So on marriage, so I started where I work, GLAD in 1990, and on my first week on the job had a request from a couple who wanted to bring a marriage case in Massachusetts. I said no, I understand, but no. We were way too early for a whole lot of reasons that I can tell you later if you want. But in any event, I wanted to get to yes eventually. And to me, that meant having to clear away in the New England states where I was focusing at the time, a lot of the underbrush of discriminatory laws and to establish some affirmative protections. And I became part of a national research project to look at all the state constitutions about where would be the most propitious places to bring the claim. And you had to look at text. Reading these constitutions really matters, and sometimes the language is unfamiliar because we're all focused on the federal constitution. And there's usually rich precedents, or sometimes things haven't been interpreted actually. So looking at that, and then also looking extremely importantly at the process for amending constitutions. So if one were to win by some miracle, what would be the process for undoing that win? And also looking at the state's sort of positive law about did it provide any protections or recognition or acknowledgement that gay people exist, might have families, kids, non-discrimination protections. All of those things went into the mix, and not surprisingly to me, in part because I was familiar with the work that other people had done before me, the New England states popped up as the best places for sure to bring these claims, and the first was Vermont. for a variety of reasons, and the second was Massachusetts, and we litigated in both places and eventually in Connecticut. And I think Vermont did everyone a tremendous service, by the way, in sort of being the first to say that the Constitution applied to same-sex couples and should have the same common benefits, which was the language there, 1777 provision. And in Mass, we were litigating under a provision that's actually very common in state constitutions about how all people are born free and equal, or endowed with natural, inalienable rights to liberty, the pursuit of happiness, safety, and so on. There are actually conservatives who say that those natural rights clauses are a confirmation of liberty and really are textual support for protection of unenumerated rights. Whatever. So in any event, those are the kinds of things we litigated, but I will say this, that it's one thing to sort of find a great venue, right, and the right case law, but that certainly was not enough. And for us, at least, in thinking about this, I think we had to assume from day one that when we filed the case, there would be an amendment process, whether we won or not. And so baked into all of this work years before we even filed these cases was trying to build up allies and support education about what is marriage. It's not what it was in 1780 when Mass, ratified its constitution. It's become this civil right. It's become something that's a marker of family. It's become something that's just freighted with so many protections for families and individuals. It's an incredibly important personal choice, et cetera. So we had to educate people about what is marriage, as well as the Constitution. And for me, one of the really exciting things about this whole area was, we won, it was Chief Justice Margaret H. Marshall who wrote the opinion in Goodridge, 4-3. And somebody just said earlier, profile and courage, I couldn't agree more. It was very hard to be first. But one of the other things that I just really appreciate about the state constitutional law decisions is it makes the decisions and the issues so personal and so local. And we won in court, but the reason we kept marriage in Massachusetts is because of popular constitutionalism, because people got engaged about what does equality and liberty mean. You had people, who were in constitutional convention saying things like, this decision is so far outside of my comfort zone, but I can't disagree with it, it's right. Somebody else's equality is not measured by my comfort zone. I mean, on and on. It was 3 really long years, but eventually more than 3/4 of the legislature, because of all of the popular support and people changing their minds and so on, effectively ratified that decision as well.
It sounds like you were quite intentional about finding text. You went and read state constitutions. How many people have read their state constitutions? Stunning. Some of them are very long and boring. I read the parts about intergovernmental relations, and
well, that's your
fall
problem.
asleep.
Try Article 1.
There are a lot of rights in the
That's where the rights
That's
are.
all where all the rights are. And also thinking about the back end, because state constitutions are so often so easy to amend. There's just a more active dialogue between the people, so to speak, and or the legislature in some cases. So there's a faster amending process in many cases. So then you have to, that can be bad if you win, but
there is, except I will say, with respect to both Vermont and Massachusetts, it was going to require 2 different legislatures to amend,
so
and that time was critical.
Yeah. So deeply knowing how these mechanisms work is quite important. Alice, do you want to talk a little bit about education finance reform? That's a longer term, that had been a longer term.
Sure.
If you want, you can talk about
I can talk about anything.
But
well, I'll try to stick to the topic, but thank you. And thank you to ACS, and it's really an honor to be on this panel. I do think as an advocate, when you're starting to look at a problem that you're trying to solve for your client or your organization, I represent 3 million educators across the country, you've got to look for every possible tool you have, right? You can't come in and say, oh, I went to law school and I learned all about federal courts, so how do I get into federal court? How do I make the claim stick? If you're challenging a state law and you're seeking damages against the state, you have to file in state court. And so you want to see whether or not you have any claim under the state constitution. And as Mary was saying, the state constitutions are incredibly robust, right? Nobody carries around a little pocket-sized copy of state constitutions because they're, I don't know, the California Constitution is what? It takes up a shelf?
I carry a wheelbarrow.
So you're going to find something if you take a look. And you're going to want to look, I mean, if you're in the education context, state constitutions, of course, have very robust language around what the state's duty is to provide an education system, either a thorough and efficient education system, an adequate education system. They also often impose a paramount duty on the state to make provision for schools, which has been interpreted in some states to require the legislature to fund schools first. So you might have very unique tools for going after a particular problem in your state constitution. That's also the case with respect to state legislative process issues. State constitutions frequently have very specific requirements as to that a bill has to have one subject, that the title has to reflect the subject of the bill in order to prevent log rolling, that the legislative session that's called for a particular reason can only consider bills that fall into the reason why it's called, that legislation cannot be special, that it has to apply uniformly statewide. And those kinds of legislative process guarantees are provisions that are just not available at all under the federal Constitution and can be enforced very effectively in state courts. You also need to think about what kind of conversation you're trying to create, right? Are you trying to create a floor, a fundamental right to education? Wouldn't that be nice? So under our federal court system currently comprised, I think that's a vanishing goal long in the horizon. But maybe what you're trying to do is create the conversation at the state level around particular rights, as Mary was talking about, for marriage equality, and educating people around a particular set of rights, the conditions of the schools for particular groups of students, and that's where school funding litigation can be very effective, because you're really trying to use the state court system both to get a short-term win, or I shouldn't really say short-term because school finance litigation is very long, but to prod a legislative process along, which has not been effective.
Caitlin, do you want to talk about some other areas in which you might see some opportunities in?
Sure, I think one of the most interesting areas, and let me start by saying it is such a pleasure to be here today, and especially to have the chance to talk about state courts and the opportunities to litigate there. I think that for folks who are interested in public law issues, remembering especially these days that there are a lot of places outside of Washington, D.C. where you can advocate for issues you feel passionately about is really important. So it's especially nice to be part of that conversation. I think picking up on what Justice Earle said, one of the most, I think, promising areas for advocacy right now at the state level is in the criminal procedure arena for a couple of reasons. First of all, unlike some of the litigation that rests on a public nuisance theory, so for example, the climate change cases, there's really no opportunity for preemption by federal law. Same thing with gun cases, right? There's a federal statute that makes those cases very difficult to bring. State courts have really, I think, a very clear field when it comes to setting criminal procedure under their state constitutions. And I've seen some of this in New York that is really very innovative, and I'll give you two examples. So under the state constitutions, the language in the New York Constitution tracks what's basically the language in the Fourth Amendment of the U.S. Constitution. But the New York Court of Appeals, which in New York is the High Court in New York, for whatever reason, the trial court is called the Supreme Court, and the High Court is called the Court of Appeals. So the New York Court of Appeals has developed a very robust jurisprudence that governs interactions between law enforcement, between police officers and citizens. So under New York law, interactions that come before an actual stop or an arrest by a police officer are cloaked with constitutional protection, even though under federal law they are not. And over the past 18 months in the New York High Court, there has been a really interesting back and forth on both sides about whether the protections that are given maybe are not strong enough or maybe are too robust and interfere with the ability of law enforcement to do their job. There was a very powerful dissent in a case last year that 2 judges wrote that was looking at interactions between law enforcement officers and citizens in public housing buildings in New York City, where the police have fairly free rein to come in and walk around, and they stop folks and ask them if they live there or not. And so what those 2 judges were suggesting was that even more substantial protection should be accorded in those circumstances, because it was not enough. The rules that were in place were not enough for folks to feel like they really did have an opportunity not to engage with the police when they were approached in that setting. And so keeping an eye on where that's going, as we're seeing a lot of other issues on the criminal justice front evolve, I think is important. Another area where there's been, I think, some really promising development is in the area of wrongful conviction. So I spent 4 years in the Manhattan District Attorney's Office, and we took a close look both at how to review claims of innocence in old cases where there had been a conviction, but also what procedures to put in place to reduce the chances of wrongful convictions going forward. And there is now a lot of social science literature which makes clear that eyewitness identifications, particularly in the absence of any corroborating evidence, are vulnerable to mistakes, not intentional mistakes, but to glitches in your cognitive processing that lead you to identify the wrong person. And that those cognitive mistakes are especially apparent and likely to take place with a cross-racial eyewitness identification. So a couple of years ago, the Court of Appeals was hearing a case about an eyewitness identification in which there was an allegation that it had been mistaken. And so I pulled together a coalition of former judges and prosecutors, and we wrote a brief to the Court of Appeals saying that the court should require a jury instruction which informed the jury about the risk of mistake with cross-racial eyewitness identifications. And the court took us up on our invitation. There was also an amicus brief from the American Psychological Association that laid out in some detail the ways in which these mistakes are made. And a couple of other states had adopted a similar approach, New Jersey most prominent among them. So now in the New York courts, if you have a cross-racial eyewitness ID, a defendant has the right to a jury instruction which explains the kinds of errors that can come up in these cases. So that's something where, can't have Congress preempt that, right? Where I think it can make a very significant difference in reducing the risk of wrongful convictions in cases going forward, and also where the state can really experiment in that classic Brandeis way and see whether or not this works, what wrinkles there are, and put that out there for other states to look at going forward.
It's notable that we're not just talking about state constitutions, we're also talking about state common law, state statutory law, the environmental cases you raised, which are on public nuisance, which is a doctrine that the federal courts aren't applying, it's only in the states. One of my favorite cases is the early 1970s Mount Laurel case in New Jersey, which is struck down exclusionary fiscal zoning, exclusionary zoning, based on common law and state constitutional grounds. And much of it was explicitly to insulate the decision of the state Supreme Court from override. I want to bring Judge Sutton in. You've written extensively now this new book, newish book, about the 51 opportunities out there. I wonder what federal courts can do to facilitate and prioritize sort of state independence, state judicial independence.
Yeah, well, first of all, I'm really thrilled to be here. Thank you for the invitation. It's funny to me that I met Goodwin at a national convention probably 15 years ago, and we were debating the U.S. Supreme Court's federalism decisions, and I'm quite confident we were on opposite sides of that debate. And here we are talking about states from a different angle and very much on exactly the same page.
You persuaded me.
No. Well, the glib answer of what the federal courts can do to promote state constitutionalism, you're not going to like, and that's nothing. But let me circle around this a little differently, because I want to emphasize a great feature of the Brennan article and then offer an explanation for why it hasn't succeeded in the way I think he hoped. The great feature of the Brennan article was that it reminded us that there are two shots, not one, to protect individual liberties, three if you include cities. The key point, the key lesson from the Brennan article is if the US Supreme Court puts up a stop sign, they say no to a right. That's not the end of the story, and we've already heard some examples of how that could unfold. And in fact, not only unfold at the state level, but then get the US Supreme Court to reconsider earlier decisions. See Baker, see Bowers. And I don't know if Mary mentioned it, but Bowers is a case from Georgia, Bowers versus Hardwick, and long before Lawrence, the Georgia Supreme Court, under its state constitution, effectively reversed, disagreed. So the great feature of the Brennan article is to remind us two shots, not one, in a federalist system, very liberty protective. The problem with the Brennan article is that it should have been written by Justice Brandeis, because Brennan centered everything in the article around federal law. So it was, if we can't win at the US Supreme Court, read my dissents, construing the US Constitution and make them your state constitution's guarantee. And there's nothing wrong with that, and I'm as vain as any other federal judge. But it really was not a way to dignify and develop independent state constitutional law. So I know I'm a guest here, but I'm going to give you a brief assignment, quite unenforceable. Just take 3 minutes to read Article 1. It's likely Article 1 of your state constitution. You will be blown away at how often the individual rights guarantees differ linguistically from the Bill of Rights, 14th Amendment, etc. So the thing that Justice Brandeis would have done had he written the article is he would have said, have you heard of my laboratories of democracy point? And it's so hard to get Americans to agree on anything in this day and age, but no one challenges him on this point. If you've got a new policy problem, opioids, data privacy, let a brave state deal with the challenge, experiment, much less high risk to experiment at the local level. If it works, another state can adopt it. Now, of course, his laboratories of democracy were state legislatures. All we're saying is why not take that model and have laboratories of constitutional experimentation at our 50 state courts? The guarantees we fight most intensely about all originated in state constitutions, and the ones we fight most intensely about are all written in language that is very general. It is language that lends itself to differences of opinion, different approaches, and yet, unlike so many other areas of American law, we've got this top-down approach to developing con law. Feds first, and then you can deal with the loss at the state level if it doesn't go well. I just don't quite understand why we're not doing it in the reverse. From the ground up, go to the state courts, win locally, have the courage of your convictions, another state court can adopt it. And I'll try to illustrate this by going to Caitlin's point about opportunities in criminal procedure. I couldn't agree more with this point. I thought the number was 84 million in the state courts, but whether it's 50 million or 84 million, roughly half of them are criminal cases. All right, so it's 25 million or 42 million criminal cases every year. Every one of those state cases, the US Constitution and a state constitution applies. In most of those cases, people aren't bringing the second shot. So to illustrate how uneducated we as a legal society and a society are about this problem, think about our policing problems over the last 5-10 years and how many hundreds, if not thousands of people have been focused on trying to deal with the situation where you've got communities that are not trustful of law enforcement. If one were to look at one potential problem in some of these communities, what would it be? In my view, it might be a US Supreme Court decision, Terry versus Ohio, June 1968, during an election year, 8-1 decision written by Chief Justice Warren, where he says, 8 people join it, even though it is a seizure, you don't need probable cause. I'm not aware of a single lawyer in this country, not a single one, that has gone to a state court, say Missouri, Maryland, and said, you know, we don't have to follow Terry in our state. And given some of the problems we have had in our communities, we're not going to follow Terry. In fact, this is really going to bum you out, or at least turn your head around. There's one originalist decision in Terry. It's written by, of all people, Justice Douglas. So the dissenter writes an originalist decision. You know, no one is making this argument because no one thinks there is a state constitution. No one's read their state constitution. No one teaches state constitutional law, and yet we're all incredibly unhappy about certain things going on, and we're not even thinking about that incredibly important argument that I would suspect there were a few state courts out there that would pay attention to.
So this all sounds terrific. States are the best. But
This is why I accepted the invitation.
yay, states. And then we look around and we say, so progressives have been historically suspicious of states, and you note why. One is obviously the history of racial subordination and oppression in the South, and other groups, and the civil rights problem, the Jim Crow problem. And so what is it about, say, the Supreme Court's, and this is open to everybody on the panel, should progressives back the Supreme Court's anti-commandeering doctrine? Should it back its coercive spending doctrine, right? All these federalism doctrines. Should it back a retreat on preemption of, say, environmental laws or any other parts of the administrative state that the left has spent a lot of time trying to protect? And there's a movement to dismantle some of those things, in part for justified by states, not states' rights, as that language isn't used so much, but state power. Is that something progressives could be comfortable with? Should they be comfortable with that? What about the dark side of the states? Anyone want to jump in on that?
Well, I'll offer a little bit of historical perspective. And I think it's painting with too broad a brush to to portray this as a debate, state bad, federal good. That is kind of the way we are taught, actually, in law school. At least in the era in which I went to law school, that was true. But the framing of that debate, I think, quite interestingly, happened just a few hundred pages away from the Brennan article in the same volume of the Harvard Law Review, 1977, with Burt Newborn's article called The Myth of Parity, in which Professor Newborn argued that federal forums are far more hospitable places to bring civil rights litigation than state courts. And in fairness, Newborn was comparing trial-level forums, but I think the extension has been made to judiciaries generally. Consider this. Consider Brown versus the Board of Education, right? The quintessential triumph of federal power, federal judicial power over the states. If you recall from your constitutional law course, the path to Brown is narrated through a series of higher education decisions, starting with the ones in Texas, Sweat versus Painter, and then there's one in Oklahoma, the McLaurin case. And those built on a prior one in Missouri called Missouri versus Gaines. Gaines was a case about a policy of the state of Missouri not to provide a black law school for a qualified applicant, but instead to offer that qualified applicant a ticket out of Missouri to go to have a scholarship essentially to go to a neighboring state. And they called that separate but equal. The Supreme Court struck this down. It was the first significant decision by the Supreme Court striking down a segregated practice and ordering the integration of a public educational institution. What did the Supreme Court rely on for that decision? The Supreme Court relied on a decision by the High Court of Maryland in a case called Pearson versus Murray, which was one of the first cases that Thurgood Marshall litigated as a young attorney in Baltimore. Similar facts. The state of Maryland had an all-white law school. Gaines was a very qualified applicant, and through a trial in state court, Thurgood Marshall and Charles Hamilton Houston exposed the fact that the state really had no appropriation or no clear intent at all to provide an equal education for the qualified black applicant in another state, and so the only remedy was to order the integration of the school. That was the High Court of Maryland in a seminal decision which set in motion all the other pieces. Now, think about the Brown litigation itself. Most of you perhaps remember that Brown was 4 consolidated cases, one from Kansas, one from South Carolina, one from Virginia, and one from Delaware. The Brown case was the Kansas case, and that case plus the Virginia and South Carolina cases were 3-judge federal courts, all of whom had denied relief to the black plaintiffs while finding certain facilities to be unequal, gave the school districts more time, essentially, to kind of bring the facilities up to par under the separate but equal standard. That, in effect, was not much of a remedy for the kids who were suffering the unequal part of that education as the school districts were trying to equalize. The 4th case, the Delaware case, was brought in state court. And Chancellor Collins Seitz in the Delaware Chancery Court found separate and unequal schooling in the Delaware districts, and by making a site visit to the schools, documented in great detail the extent of the inequality, and said that the right to an equal education under the separate but equal standard is a personal and present right, a personal and present right. And he said there is no remedy except to order the integration of these black plaintiffs while the schools were trying to equalize themselves. And that decision was affirmed by the Delaware Supreme Court. So consider this fact, that by the time the Brown decision reached disposition in 1955, the US Supreme Court reversed the 3 federal courts that had considered this question and affirmed the 1 state high court that had addressed it. I think that in and of itself should cause us to reconsider the traditional narrative about state and federal courts. And in fact, some of my busy law clerks, you can make your law clerks do all kinds of things, have helped me look into the history of all these pre-Brown decisions, because I've been very curious, actually, about the traditional narrative. And it turns out that if you look across more than 100 of these lower court decisions from the late, I would say the mid-1850s up through the time of Brown, I think the results are quite mixed, actually, in both the federal and the state courts, which perhaps suggests that judges generally are, they are products of their times. And whether you are appointed in the state court or federal court may matter less, actually, than other sorts of influences that influence your professional outlook, the norms of your community, all these things, right, that go ineffably into the process of judging. So I would say that if you're interested in you have to think much more surgically about the question of what is the more hospitable forum. And I mean, as the entire premise of today's morning panel, and indeed some of what we're witnessing, as the premise of this convention is, no one would say that the US Supreme Court today is where all of you plan to go to get your individual rights vindicated, or at least that is the implicit criticism, right, of much of what is being discussed. Well, I mean, so how do you weigh across a broad swath of history, whether or not the federal courts are or are not doing an adequate job? We can hope, of course, that for our preferred results, but we have to take, I think, a far more nuanced and complex picture.
So, Justice Earls, is that why you ran for state office instead of, say, doing something else, concentrating on the federal level? Is that a strategic?
I certainly understand the premise, as you said, of the morning panel and sort of where we are politically at the federal level. But I think this is not an either-or question, and it's also not a one-size-fits-all question. But I wanted to be on the state court bench after the experience of litigating partisan gerrymandering and racial gerrymandering cases in both state and federal court, losing in state court, winning in federal court. And we are going to get, in the next 3 weeks, a decision from the US Supreme Court on the question of partisan gerrymandering, and I think it's really important that any discussion of why state courts are a favorable forum or why some state courts may be a place where you want to bring your claims can't be allowed to let the federal courts off the hook. When the Maryland and North Carolina partisan gerrymandering cases were argued earlier this year, two justices said, why do we even need to rule on this? Can't state courts deal with it? And which in some ways could be seen as just an abdication of federal responsibility to enforce the US Constitution as well as state courts' responsibility to enforce their state constitutions. So I do think it's important. I guess my point is, as progressives, we have to be in both places. And exactly which cases you bring, exactly when and where, are always strategic decisions that you'll make, based on your best judgment. But you can't abandon either forum. And your strategies may be very different. Sometimes the civil rights bar is trying to keep those cases out of the US Supreme Court, but we have to be skillful at using the best doctrines we can in both forums.
Yeah, what do you all think of that final comment? So one response to all this is, oh boy, this is just sort of opportunism, right? Brandeis was faced with a hostile federal judiciary, so he says, go back to your states, do your work there. That way we can have some progressive legislation at that point. Brennan is faced with the same problem in '77, an increasingly conservative course. Go back to your states. Is this just a cyclical phenomenon? Is there a principled way to think about this? Are we just in another place with hostile federal courts, and therefore the state courts is where progressives need to go by necessity?
I did. Good.
Yeah.
We're actually law school.
So you guys
we
have
can
done this
finish each
before.
other.
Yeah, I was going to say.
Yeah. I'll go first and you go second.
Okay.
How about that? I think there are practical considerations that tie to some of what Justice Earle was saying that are a bit of the be careful what you wish for variety, right? So like Judge Sutton, I was lucky enough to spend a number of years in the state AG's office, and we litigated Massachusetts versus EPA. And we thought we were very clever in persuading the Supreme Court that as states, we had what we called special solicitude, and therefore we should have an easier time showing standing and getting into federal court. And that case worked out incredibly well from a progressive point of view, and required that the EPA actually go back and look at greenhouse gases and determine whether or not they were something that needed to be regulated. Well, fast forward a number of years, and when the Obama administration finally promulgated the Clean Power Plan, which put in place pretty significant changes on the emissions front, a number of states led by West Virginia came into court and argued that it was arbitrary and capricious and all kinds of other bad things. The standing decision that we had obtained in Massachusetts versus EPA was very helpful to them. And now again, I think you see the same circle, right? You obviously see a whole lot of blue state AGs who are in federal courts, including the Supreme Court around the country, and the standing arguments that they are making are the same ones that red states made in challenging Obama administration regulations. So I think that there is something that is sort of trans-political about some of these doctrines. Maybe not preemption, because I think preemption is more frequently used to really draw a line in the sand with respect to state protections, which often benefit, I think, consumers. But with respect to some of the broader doctrines like anti-commandeering or standing, I think what you think about whether it's good or bad may depend a lot on who's in what office at what point in time.
And to the extent that you're enforcing unique state constitutional provisions, it's not opportunistic at all, right? You're enforcing state mandates that the people of a state have adopted into their constitution, maybe very recently. I mean, these state constitutions are very robust and dynamic documents. And so if you're going to enforce them, you're going to enforce them in state court under the state constitution. So for example, there are 4 states in the country that provide protection for public sector workers to organize and to bargain. Florida, Hawaii, New York, and Missouri. And so when Missouri passed in this past year, basically a Wisconsin Act 10 piece of legislation stripping away workers' ability to organize and to maintain an organization and to engage in political activity, we went to court and challenged it under the Missouri Constitution, Article 1, Section 29, which guarantees the right to organize and bargain to public sector workers, and we won at the trial court level. I don't think that's opportunism. I think it's smart advocacy and also enforcing a state constitutional guarantee.
And in that same vein, you know, there are times when you have basically the same language, and the state's going to come out a different way. So take the death penalty, Washington, Connecticut, you know, looking at the evidence, which is really irrefutable about racial and economic disparities, and come out a different way. And I think that has to be okay in our system. So that's one thing, but I really want to just go back to Alice's point too, in terms of the unique provisions, because, you know, in about, I think it's roughly a third of the states, there are specific provisions about health care. Now, have they been transformative? No. But they should be. And it's the kind of thing to think about. There are specific provisions in a number of states, and some of them are very old, about providing, you know, support, overseeing, caring for persons who can't provide for themselves, you know, no shelter, need support. Again, some of those have, you know, been long-term litigation and so on, but that's another thing, in my view, that really requires re-examination. You know, prisons. There are several states that actually specifically mention incarcerated people. And there's this incredible 1981 case from the Oregon Supreme Court, Justice Lindy, who's like one of those real teachers and big state constitutional people, that essentially said, you know, there were women who were women guards patting down men, and talked about the dignity of all people. And the real question was, you know, is this really necessary in light of our constitutional language that says individuals who are incarcerated shall not be treated with undue rigor? And, you know, some just like, well, it's convenient for us, or gosh, we don't want to like limit women's opportunities. You know, it didn't cut it as well that they shouldn't. So anyway, I just feel like given so many of the incredibly pressing problems that we have, and given the textual hooks that are in our state constitutions, I don't know how we could look away.
Yeah. So it seems to me there are two types of sort of state independence. One is just state substantive constitutional provisions. They don't have analogs in the federal. There are avenues to do this. Education looks like that. These dignitary clauses might look like that. Lots of things in there. And then there's the intergovernmental relationship between the feds and the states. And the federal courts are doing a lot of the latter. They have to decide commandeering, coercion, those kinds of things. But we might want them to stay out of these substantive things. And maybe those are substantive things like same-sex marriage or gun rights or various other substantive. The Supreme Court doesn't seem to get that message, and maybe that's good. That's what you want, but there's good and bad. In your book, Judge Sutton, it talks mostly about
Jeff's fine.
Jeff. It's very hard to say that. I'm not a litigator, so it's yes. I'll call you Jeff. That's
Professor
easy.
Schrager, do you want me to start doing that?
Yes. Your book is about a lot about substantive, not about, again, intergovernmental relations. And you have an interchange with Justice Liu in the Yale Law Journal, which is quite interesting, where you agree about most everything, even though I think ideologically you might be in different places. Is that just happenstance? How do we get that agreement? Is it just you guys have convinced each other?
I tend to think it's because we're so right. I mean, think of rights like money. Forgive me for a second, but just stay with me. No one would take all their money and put it in stocks. You put it in stocks and bonds. Think of federal rights as stocks, state constitutional rights as bonds. And as Warren Buffett says, you know, economic tides come in and they come out. And when they go out, you see who has their bathing suit on. And people that diversify their individual rights protections, when the tide goes out, you see who's protected themselves. It's just time, rights, there are rights with tides coming in at the federal level, and there are time when they go out. Now, back to the federal point, because I do think this is a big dialogue issue where I feel like we're not paying attention enough to this, and I blame we Americans as much as I blame the US Supreme Court for this. We're in rights escalation mode right now, right? It's red right 1 year, blue right, red, blue. We're free to stay on that path, but I think it's quite delusional to think that the US Supreme Court is always gonna see it your way. So if you really like the winner-take-all rights victories at the court, where it's constitutionalizing, it's going to come with just as many cases where they constitutionalize what you think you ought to have a right to vote on. And it seems to me, one of the reasons why we shouldn't just think of states in terms of Jim Crow, but should think of it going forward, is maybe this is a time in American history where it really makes some sense not to think of them as either or, but that we can use the states and state courts, state legislatures as a place to develop rights, and you can still nationalize. This is not mutually exclusive. But the stakes are a lot lower when the US Supreme Court nationalizes a right with 5 to 10 outliers than stakes when you're really taking democracy away for half the people. But that's just, and that leads to backlash. There's just no doubt about it. I mean, we just had a presidential election which turned on a sufficient number of people treating their vote for the President of the United States as a proxy to fill one slot on a 9-member court. I mean, that's a really astonishing thing. And the worst of it is it was deeply rational. That's the very worst part of it. The court's exercising a lot of power. So I think we have to decide if we want to keep the focus on the court, great. But for everyone you win, you're going to lose one, and you got to take the bitter with the sweet. Or maybe a little less of the winner take all, at least at the outset, and a little more of this getting developed at the state level before you get the national ruling. So I'm very much against the view that it's one or the other. I'm very much of the view that these should be working together and that the federal courts can really learn from the state courts with these 84 million to 50 million cases a year, probably a lot better insights than any of we federal judges have about how justice is really working at the ground. So I just want more of a dialogue is what I really want.
So I'm a state judge, so I'm going to have my bathing suit on when the tide goes out. But that's quite an image, Jeff. But I think it makes a good point.
It catches their attention.
It does
I'm telling you, it catches their attention. Everyone's got that anxiety.
And I think that makes a very excellent point. And I think your basic point that you have to be careful what you wish for is what every smart litigator thinks about. I would just say that one of the things that appeals to me, you asked, Rich, why Jeff and I have some agreement. I think even if Jeff and I disagree on the edges about particular results, I think the focus of the way we understand the conversation, I think, is where the point of agreement is. One thing I like about Jeff's book is that it narrates this issue through a series of historical narratives on particular topics. He has a chapter on school funding. He has a chapter on Buck versus Bell. He has a chapter on the flag salute cases. He has a chapter on the exclusionary rule. And what he's doing is he's taking account of how things actually happened in constitutional history. And I don't know if Pam Carlin's here, but Pam and I wrote a book with Chris Schrader some years ago that was trying to do the similar thing, which was to try to understand how we read the Constitution in light of actual lived experience with the document, right? And if you think about all the kind of classic debates we have in law school or even at forums like this about originalism or living constitutionalism or whatever it is, these tend to be kind of slice-in-time arguments, like the all-encompassing theory of how you read the Constitution at X point in time, and in order to produce a particular meaning or result about the Constitution. This, I think, is interesting, but not ultimately a fulfilling inquiry, because much more textured and rich, I think, is thinking about what is the process of constitutional change as it actually happens in the American system that we have? And as lawyers, actually, that is the more relevant question. You may call it opportunity. I think opportunism is, I was trying to think about your question. Of course lawyers are opportunistic. That's your job. You have to zealously defend your client and pursue your cause. You are going to be opportunistic all the days long. The point is, we ought to think harder about the process of change, and the principle that underlies it all is that we have been bequeathed a system that enables that process to develop in this multidimensionality, and we ought to think harder about about the way change is made in that system, instead of centering our debate in this much more narrow sphere, which I fear, actually, I think Jeff is right, produces a much more highly politicized notion of the judiciary than, in fact, most of us workaday judges experience.
So, say a little bit about, it was interesting, Mary, you talked about kind of integrating the political view into the litigation strategy. And it sounds like what you were doing was integrating the possibility of backlash into the, is that something that progressives need to be really aware of? They need to be highly attuned to and need to pick and choose their battles very carefully for that reason? Is it something that lawyers can actually deal with at the strategic level? Or is that just very, very hard because we actually don't know how the political winds will blow down the line?
Well, obviously I'm a cause lawyer, bring impact litigation and so on, and so I'm not representing somebody in an individual case where they could bring a claim under the state constitution to say that the search was unauthorized. And I encourage people to bring those cases. That's a both and to me. If you have a colorable claim under the state constitution, it seems generally advisable to bring it. But what we are doing in the litigation that we have done in these areas is not just about the backlash, but it's about trying to engage the public the whole way through the litigation. So it's not a secret, and there's years, sometimes years, before the litigation is filed to prepare the way, so to speak. This is a federal court example, but like after we won Goodridge, people kept saying to me, okay, so now you're gonna challenge the Federal Defense of Marriage Act? I was like, yeah, I started looking at it, yes, but there was no way in the world I was going to litigate that at that time, and we didn't file a case until 2009, and before we filed, we talked to actually well over 1,000 people about the problems that they'd had, and figured out a way to get that information out there and to get their stories out there, and it started getting people concerned and upset, and so by the time we actually filed that litigation in 2009, like there was a reason it was being filed. Like more people understood that there was a real problem here. People in the Congress, some of them at least, understood that there was a real problem here. So we really made that case, and I think on many issues, probably not all, but there is a way, and again, if you're in a public interest kind of litigation outfit, to really be thinking about public education the whole way through and to figure out, I know it's easier said than done, but to find those common values where you can agree. I'll give you one more example. Okay, so on the marriage front, after we won in a couple of courts, the next issue was, would we ever win in a legislature, which of course our opponents said we wouldn't. And we started winning in 2009. Vermont overrode a governor's veto legislature, and then Maine was next, which is the state where I live. But then there's a process to put it on the ballot. So it was put on the ballot, and we lost basically 52-48. And I hate being voted on, I'm just going to say. But in any event, we also realized that we also had 8,000 volunteers in this campaign, which is incredible for such a small state. And we had to go back. But the way we went back was in a 3-year campaign that involved a very heavy measure of door-to-door across the state, where it was conversations where I'm here to talk to you about marriage. You want to talk to me about marriage? Why is marriage important to you? Can we talk about why marriage is important? And that whole approach changed everything, actually, because people did appreciate the conversation. And then the people who appeared in our ads, World War II veterans, firefighters, and so on, were people we'd met at the door who were like, how can I help? So I know that that's Maine. It's cold, right? And it's still pretty big for a northeastern state. But I just don't know a way forward about how to get consensus without having that kind of work. Otherwise, you do get very much more of resentment, whether it's merited or not, about people getting the rights they deserve.
Politicization was raised. It's sort of there is a dynamic going on, right? The politicization of the Supreme Court, as you point out. What about politicization of the state court? That's a problem too. Elected judges, justices.
We're fair and impartial. I do think, expanding on this idea that state courts are laboratories, they're not only laboratories about the development of doctrine, but they're also laboratories about how judges should be selected, because you have a variety of different methods. And I would submit they're laboratories about the impact of diversity. Our state Supreme Court now has, out of 7, 3 African-American members. We have, for the first time in history, an African-American woman as Chief Justice of our state Supreme Court. There have only ever been 4 African-American women serving as Chief Justices in this country. But I think it varies from state to state, but they are also laboratories for diversity and the impact that that has on the development of doctrine.
So I've gotten my questions, and some of you are very neat writers. Actually, all of these are quite good. They're very good. So we're going to start with these questions. But besides doing away with Terry, does the panel suggest any other state constitutional rights, criminal procedure or otherwise? Thoughts about, we've said a few, but thoughts about other areas in which you might, Terry's a big one.
Criminal procedure is a great one because of the volume of cases, but I guess I might just urge you to think about it. I made the mistake of setting this up in the wrong way, because it's just, if you go out and do this, this is the mistake everybody's making. You bring your second shot, you're like, oh great, 2 shots are better than 1. But all of your thinking about the state shot is going to be around the presumption that the federal way of thinking about it is the right way to think about it. So in every state court in the country, but Oregon, I guess maybe Maine and New Hampshire are exceptions, but let's say at least 47 state courts in the country, the rule is you start with the assumption, the presumption, that whatever the federal guarantee means, that's what the state guarantee means. So in other words, Washington, D.C. is where you get your first indication of what the local guarantee means. Now just ask yourself if that makes sense given the way we think about localism. So if I left a bench tomorrow, ran for the legislature in Ohio, and my first question as I'm out speaking is, Jeff, what do you do when you have a really difficult policy problem? You're going to be a new legislator. How are you going to work on it? And I said, oh, it's easy. My first question is, what would Congress do? Or I'm running for governor. Same question. What would you do? I'd ask, what would the President of the United States do? I would be laughed out of every state in the country. There is no state in the country where I would not have just ruined my political career. And yet 47 of the state courts in this country think you should start with the assumption that the answers about the local constitution come from Washington, D.C. So you shouldn't be thinking about it in terms of what's ripe as to this area of federal con law you don't care about or care for. You should be thinking about in terms of what are the local problems we have. Read the state constitution and figure out why they might be customized to deal with that local problem, and stop having this gravitational pull to the federal document. That's not how we think about other policy problems, and it's so strange that we keep insisting on doing it with the Constitution, or constitutions.
Yeah, there's this doctrinal lockstep in lots of areas, which is it's a funny thing, right? That the state, now maybe it's just this, they're pretty persuasive up there and they've said something intelligent.
If there's one thing you should have learned from today, the state judges are smarter than the federal judges. That's easy. We'll take a vote, it'll be proved, I'm pretty confident.
Yeah. When you guys have litigated, have you found that mainly you're kind of teeing off of the federal, whatever the federal claim, whatever that looks like, and then trying to work around it, or much less so because you have substantive constitutional rights that are independent?
If you have a substantive, first you figure out, do you have a substantive state constitutional right? And then you look to see, do they have the lockstep doctrine? And then if they have the lockstep doctrine, which means they've tagged their state constitutional jurisprudence to whatever the federal court may decide, which is just crazy. right?
Yeah, yeah,
For a
yeah.
state court to give that authority away to other judges that have no accountability
Peg
to the
themselves to
state
the dollar or the
whatsoever.
euro.
And then you look for, if there's a lockstep doctrine, you look for, how far does it go? Is this particular area excluded? If you can't exclude it, then federal court looks better and better.
Right.
I think your last point is especially important, to look at how broad the lockstep doctrine is, because if you're in a state where they may look to the federal law first, but for example, in New York, under the First Amendment, under the equivalent of the First Amendment under the state constitution, the doctrine's very clear that they do not feel themselves bound by that. And there's this very interesting strain of doctrine where they say, well, in New York City in particular, we are a place where there's been this extraordinary development of the arts, and we care a lot about protecting speech. And so in state court, if you have a First Amendment claim, you can argue whatever you want. And it's incredibly exciting, because it is if you are going to the US Supreme Court, because it's a high court, and you're not bound by whatever the federal precedent is. And so I think that you're encouraging folks to look beyond the lockstep. If there's doctrinal room to do that, is really important and can open up the door to a lot of arguments that you wouldn't see anywhere in any pages of the US or federal reporters.
So that I can imagine also being in state court and bringing federal and state claims, including in a state that locksteps, thinking that you might try to get a dissent to say, I think we should have considered the state constitution, and because nobody's a judge forever, personnel change, and you make your argument about why textually, sorry, I didn't mean that's the way it sounded.
Big divide
Okay,
on the
sorry.
panel. Yeah, people
No.
contemplating their mortality, I guess.
Well, you make the difference why textually, you look at sister state precedent under their state constitutions, like common conditions, what we've learned now. I mean, there's ways to say, actually, maybe we need to reconsider lockstepping.
So, second question, is there any law school in the country that has a course in state constitutional law, or any nonprofit entity that has funded studies in this subject? Yes.
There's like 25 states, 25 law schools to teach it. We need, the 200 law schools. We need more. And I don't know of any funding group. I don't know of that.
You brought the book. So
I'm sorry. May I?
Flash it? Yeah.
So this is going to go on the reading list. This is a gentleman named Robert Williams, who's just retired from Rutgers, who's really a dean in the field of state constitutional law. And I actually learned from reading your articles that we have that in common. We all think he's amazing, and he is. And this is a 2009 book about state constitutions that he's in the process of updating. But basically, he's written so prolifically. And the reason I met him is he came to Massachusetts to lecture about the Vermont ruling on marriage that ended up in civil unions. And then he ended up with other scholars doing a brief in the Massachusetts Supreme Judicial Court about state constitutional analysis of the state constitution there. So anyway, this guy is a treasure. And so I just really would highly commend books like this and so on to your consideration.
The Legal Academy has not, however, been focused on state constitutional law. And does it produce enough scholarship on it? There's a few experts in the country, and then it drops off quickly, and it's just not.
We need to find somebody who knows the dean.
Yeah, that's a fair point. My dean's my dean. My wife is the dean at Virginia. That's why Jeff is talking this way. You're so familiar, Jeff. It's making me uncomfortable.
I'm sorry.
So I teach state and local government. It turns out.
That's close.
It gets pretty close. Yes, that's right. Next question: how do we encourage state courts judges? Oh, we asked this question, but we can ask it again. To stop lockstepping. Do progressives make appeals based on difference in text and original history, public policy, all of the above? Any particular success stories that stand out? So we've covered some of that, but other thoughts? So if they have a lockstep doctrine, what does that even mean? They just say it for all, they say that's what we do in this particular area?
So Well, it depends on the state, but I can give you an example of Iowa. Iowa has a uniformity clause, which is their equal protection clause. They passed Wisconsin Act 10, elimination of collective bargaining law. We looked at how we could challenge it because, of course, Wisconsin Act 10 was challenged in state court and federal court and upheld in federal court and upheld by the Wisconsin Supreme Court too, which is fairly conservative at this point. And looked at the Iowa case law on how they construe the uniformity clause, and lo and behold, they have cases that go both ways on it, right? So they have cases saying, we construe the uniformity clause in line with the federal equal protection clause, and then occasionally they have cases where they depart from federal precedent, or they struck something down as a violation of the uniformity clause that the Supreme Court subsequently upheld. And so you use those, little glimmers that the court has seen it differently to try to persuade the court to see it differently. We did lose the challenge in Iowa, but we did get 3 votes on the Iowa Supreme Court, so 3 of them were persuaded that they should view it differently.
Great. Are any of the panelists concerned that federalism might beget complacency? That is, quote, I live in California where the state protects and respects my rights, so what do I care about Alabama?
Yeah, what do I care about?
What do you care about Alabama?
No, I think we should care a lot about Alabama. But I think, so if I could return to the question of politicization, which is implicit, I think, in this question, because the question is, are you going to get red states, blue states with red judiciaries and blue judiciaries, right? Right. So I would begin my answer to that by saying that to some extent, I think the bias of legal education and our legal culture, and this is no disrespect to the Article 3 judges I see in my peripheral vision, is that I think that there is something magical about having life tenure in the federal system. Must be great. However, I guess at this point in history, I would defy anyone to make the argument that the selection of federal judges today is a less political process than the selection of state judges in virtually every jurisdiction. I just think that is an untenable claim in light of what we see happening around us. So politicization happens everywhere. It's just through what form. Now, the real tragedy of this, I think, is that if you set aside the US Supreme Court, which I think is a very unique court with a very unique function in our legal system, most workaday judges that I encounter, both my colleagues on the state bench as well as all my colleagues who I meet on the federal bench, there is just a professional culture that is very dominant in terms of how people do their jobs. They are largely fair-minded people who come to different judgments, but generally follow certain norms of judging. And when there are deviations from the norms, those are kind of readily called out as such, right? This, I think, our picture of this, I think, has been distorted a little bit by the singular focus on the one court, the all-important court, in a sense, of course, the US Supreme Court. But this is not representative, which I suggested at the very beginning of the panel, of the entire legal system that you are going to encounter. So I think there is something to be said for some of the things that Jeff has urged, and indeed some of the things that I think frankly, among the progressive community should be thought about, which we heard this morning stated perhaps in a more extreme way by Professor Huck, but nonetheless worthy of consideration, which is whether the US Supreme Court should, in certain ways, right, it's back to the passive virtues, reduce its footprint, right, in American life. And this is done already, by the way, through the cert process. Think about that as a form of federalism maintenance, right? Many questions left undecided within very big strokes. I mean, the implementation of very big guarantees under the Constitution, including criminal procedure, including things like the one I see all the time, racial discrimination in jury selection. All of these things have tremendous diversity throughout the country, despite nominally some stated guarantee in United States Supreme Court precedent. So we already have this kind of practice. Not to drive it further into a controversial area, but consider, I would just leave you with this. Consider what Justice Ginsburg, my former boss, had to say about Roe versus Wade. Of course, you know, Justice Ginsburg is someone who defends abortion rights. But when asked about Roe versus Wade, she had something very interesting to say, which is that she thought that the decision in 1973, which was a case about a Texas criminal law, right, that criminalized virtually all forms of abortion, except the most marginal case, right? It was a very broad law. Could have been easily invalidated without invalidating virtually every other state's law at the time. Now, that's a very controversial statement, but consider the fact, from her point of view, that had the court waited 3 years from 1973, the Craig versus Bourne decision would have been decided. Had it waited 6 more years, the Mississippi versus Hogan decision would have been decided. In other words, the equal protection jurisprudence protecting women was on a train. And the extremely controversial due process decision, right, that had been rendered in Roe, which, you know, has consumed us in judicial politics ever since, might that not have been lessened ever so slightly with a doctrinal foundation, right, if left to percolate just a little bit further, just in a slightly different direction. Indeed, the histories are that the case that Justice Ginsburg wanted to bring as a litigator about the abortion issue was an equal protection claim in a case called Struck versus the Air Force, right, where a woman who sought advancement in the Air Force but became pregnant was required by Air Force regulation either to abort her fetus or forego advancement in the Air Force. She wanted to keep her child, right? But she would have suffered a discrimination as a result. Justice Ginsburg thought she could have won that case. And that would have been the right, in a sense, of this plaintiff to choose life. But of course, that would have established a principle that necessarily, in her view, would have swung both ways. And there is, so all that is a way to say that you have to be careful what you wish for in a judicially politicized process. And if there are things that can happen in our atmosphere to take the temperature down a little bit, I think that we ought seriously to consider that.
So on that topic, there's a question for you, Justice Earls. What are your thoughts on the recent attempt at defunding state courts in North Carolina? Asks the questioner. This might, other things like recalls, and that is immediate political backlash against decisions that state justices make.
Well, the facts in North Carolina about the budget issue was not so much any particular decision. So I was sworn in January 1st. The then Chief Justice resigned effective February 1st. Not my fault, I promise. So then our first African-American female Chief Justice was appointed, and then suddenly the budget was written to slash her staff and leave her with one law clerk. So there wasn't time for a decision yet. Is there a constant back and forth between our legislature and our courts? Absolutely. But that gave me, and I think as a candidate and now as a judge, the opportunity to go to communities and explain what judicial independence is supposed to mean. And I talk about basketball games and how judges are the referee and you need them to call fouls on both teams. And I think that at some fundamental level, like, people don't want to hear, nobody asks me my judicial philosophy in any serious way. They want to know that when they go to court, they're going to be treated fairly. And that you know, whether they have money or don't have money, what their race is, where they come from, whether they're rural or urban, people want to feel like their courts are fair. And so I feel like it's my job to translate and now that I'm a judge, what does that mean I'm going to be doing to guarantee that their courts are fair? And I think so I think there's value. Would I like to have a lifetime appointment? Sure, but we have 8-year terms, and I think that there's value that I'm answerable to the voters. and that I have an opportunity to go to them and explain why they deserve a judicial system that is fair and impartial and gives them justice.
This raises an interesting question, which is, do you see in state courts debates about, say, originalism versus living constitutionalism or other interpretive battles taking place? It seems less so, or not at all maybe, than in the U.S. Supreme Court, which is kind of notable.
I think if I could just say very briefly, I think what Justice Earls just said is extremely perceptive in describing to us how ordinary courts, I call our courts ordinary, just because we are not the extraordinary court that most attention focuses on. And I think there is tremendous value in the sense that you're right, for people who sort of dispense retail justice, which is really what the state courts do. I mean, they really do retail justice, you know, all these 50 million cases, the 84 million includes the traffic cases, right? I mean, this is a very broad undertaking, and in many states, the courts are regarded almost like social service agencies because that is much of the function that they serve in society is trying to help people get on with their lives in ways. This, I think, differs so tremendously than our dialogue about courts. If you just imagine what we've been talking about the last 2 days here at this convention, it differs so tremendously. And so we have these different conceptions, and I think if we could recenter the conversation a little bit on the sort of, you know, ordinary courts in our system, I think we would actually inspire a great deal of confidence in the public in terms of, I do still believe that the third branch of government at the state or federal level is the crown jewel, you know, of the American system. As was highlighted in earlier panels, this is not to be taken for granted throughout the world. And, you know, it is a very fragile and precious thing, you know, that we have. And, you know, some of what we see in the atmosphere risks losing it. And so I think it's important to kind of recenter the debate in some of the ways that we're hearing.
One more question from the audience. Is there some concern that when state courts create constitutional or raise the ceiling or raise above the floor of U.S. Supreme Court or the Congress's rights protection, that maybe the U.S. Supreme Court could come in and mandate a floor, or through preemption, Congress would cut back on that one-way ratchet. Do we see that as a possibility, as a worrisome? Particularly, the questioner wants to know about possibly economic rights or social rights. Thoughts?
Well, I mean, if Congress has power, of course they can preempt, and that can occupy the field. So that, I guess, is always a risk there. But normally, you really want to think about them as two separate elevators, and you can go up and down the federal one, you can go up and down the state one. Believe it or not, with a state claim, you can give it less protection even than the federal floor. Nothing prohibits that. Every now and then, religious liberties is a good example. You know, a state rule could implicate the federal, say, free exercise clause, but that's very much the exception. Normally, they're just on their own tracks, and as long as you brought both claims, the state court can do whatever it wants with the state guarantee, and the U.S. Supreme Court simply doesn't have power to say no on the state guarantee, you can't do this. They have to show, if they're going to enter the fray, that interpretation of the state guarantee somehow violates a federal law, whether a federal statute, regulation, or federal constitution. So I don't think it's a huge risk, I guess is my answer.
You might see it in takings, and you might see it in speech. Sometimes there seems to be some
And you see it in the environmental arena, right? So when you have a big statute like the Clean Air Act, when you, for example, bring a public nuisance action, there is a significant risk that state cause of action will be viewed as preempted by the Clean Air Act. Or the same thing with gun litigation, right? There's a federal statute that essentially precluded state public nuisance actions. But there are tremendous swaths of law, as I think you're suggesting, Judge Sutton. And again, the criminal procedure space seems to me to be the most wide open, where Congress would have to get in the business of passing statutes in that space in a way that they have not. And even if there's not a constitutional barrier to them doing so, it seems pretty unlikely that they would get around to it anytime in the near future. Same thing with education financing, right? there is tremendous space, I think, there because it's not an area where Congress is regulating. They're not telling the states how much money they can or must spend in terms of funding their educational system. So a theoretical risk, I think, perhaps, but not much of a practical one.
So we're just about out of time, and but I do want to give the panelists one last shot. You have this giant audience. They're eager to take up their state constitutions. Any final words?
I would just say
encouragement?
one thing. It's really not red-blue. When I think of state courts that innovate differently from the federal courts, it's almost always because the judge or the litigant found something unique about that state's history, culture, that the people of that state take tremendous pride in. So that's where I would really urge you to go, and that's usually really connects well with state court judges because they're more proud of their state than they are of their own redness or blueness.
I'll venture something if I may. Thank you, everybody, for all that you do. And in preparing for this panel a little bit, it really just occurred to me that what I actually want to do is just look at all of what you mentioned, the legislative process, government structure, separation of powers, issues in various state constitutions, and almost make a checklist because they can be very, very powerful in shutting down shenanigans by the state legislature, making sure the right person is calling a special session. This is being litigated in Wisconsin right now, and there are many of them, and they have no federal counterpart. So to the extent one is deeply invested in state work, it's actually a rich source of material.
Thank you all. Next year, cities.
Yes. Yes. Three shots.
Yeah, go ahead. Sorry.
I want to quickly say that one thing that's been very striking to me now that I'm on the other side is that good lawyering really makes a difference. If you write good briefs and you make those good arguments, you are really going to make a difference in your case and in the development of the law. Secondly, in state court, you can be arguing much sooner in your career. I mean, we have some really good arguments from people who are 2 or 3 years out of law school in our state Supreme Court. And finally, I'd make a plea for we need really good lawyers to represent all of the sides in the criminal justice system, criminal defendants, district attorneys. So I think sometimes that area of the law tends to not be lifted up. But if you're a public defender, you can be arguing a Fourth Amendment constitutional right, state equal protection claim in the context of a criminal case in the state Supreme Court, 2 or 3 years out of law school, and you could do an amazing job. So I need that.
Thank you all.